Void marriages. Article 35. The following marriages shall be void from the beginning. Those contracted by any party below 18 years of age even with the consent of parents or guardians. Those solemnized by any person not legally authorized to perform marriages unless such marriages were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. Those solemnized without license, except those covered the preceding chapter. Those bigamous or polygamous marriages not failing under Article 41. Those contracted through mistake of one contracting party as to the identity of the other, and those subsequent marriages that are void under Article 53. Article 36. A marriage contracted by any party who, at the time of the celebration, was psychologically incapacitated to comply with the essential marital obligations of marriage, shall likewise be void even if such incapacity becomes manifest only after its solemnization. As amended by Executive Order 227. Article 37. Marriages between the following are incestuous and void from the beginning, whether relationship between the parties be legitimate or illegitimate. Between ascendants and descendants of any degree, and between brothers and sisters, whether of the full or half-blood. 81a. Article 38. The following marriages shall be void from the beginning for reasons of public policy. Between collateral blood relatives whether legitimate or illegitimate, up to the fourth civil degree. Between step-parents and stepchildren. Between parents-in-law and children-in-law. Between the adopting parent and the adopted child. Between the surviving spouse of the adopting parent and the adopted child. Between the surviving spouse of the adopted child and the adopter. Between an adopted child and a legitimate child of the adopter. Between adopted children of the same adopter, and between parties where one, with the intention to marry the other, killed that other person's spouse, or his or her own spouse. 82. Article 39. The action or defense for the declaration of absolute nullity of a marriage shall not prescribe. Amended provision. Article 40. The absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. N. Article 41. A marriage contracted by any person during subsistence of a previous marriage shall be null and void, unless before the celebration of the subsequent marriage, the prior spouse had been absent for 4 consecutive years and the spouse present has a well-founded belief that the absent spouse was already dead. In case of disappearance where there is danger of death under the circumstances set forth in the provisions of Article 391 of the Civil Code, an absence of only 2 years shall be sufficient. For the purpose of contracting the subsequent marriage under the preceding paragraph, the spouse present must institute a summary proceeding as provided in this code for the declaration of presumptive death of the absentee, without prejudice to the effect of reappearance of the absent spouse. 83a. Article 42. The subsequent marriage referred to in the preceding article shall be automatically terminated by the recording of the affidavit of reappearance of the absent spouse, unless there is a judgment annulling the previous marriage or declaring it void ab initio. A sworn statement of the fact and circumstances of reappearance shall be recorded in the civil registry of the residence of the parties to the subsequent marriage at the instance of any interested person, with due notice to the spouses of the subsequent marriage and without prejudice to the fact of reappearance being judicially determined in case such fact is disputed. N. Article 43. The termination of the subsequent marriage referred to in the preceding article shall produce the following effects. The children of the subsequent marriage conceived prior to its termination shall be considered legitimate. The absolute community of property or the conjugal partnership, as the case may be, shall be dissolved and liquidated, but if either spouse contracted said marriage in bad faith, his or her share of the net profits of the community property or conjugal partnership property shall be forfeited in favor of the common children or, if there are none, the children of the guilty spouse by a previous marriage or in default of children, the innocent spouse. Donations by reason of marriage shall remain valid, except that if the donee contracted the marriage in bad faith, such donations made to said donee are revoked by operation of law. The innocent spouse may revoke the designation of the other spouse who acted in bad faith as beneficiary in any insurance policy, even if such designation be stipulated as irrevocable, and The spouse who contracted the subsequent marriage in bad faith shall be disqualified to inherit from the innocent spouse by testate and intestate succession. N. Article 44. If both spouses of the subsequent marriage acted in bad faith, said marriage shall be void ab initio, and all donations by reason of marriage and testamentary dispositions made by one in favor of the other are revoked by operation of law. N.